Hello, today I want to talk about 30.06, also known as 30-6 of the Texas Penal Code. It's probably everybody's least favorite statute, and it's basically been around, I think it started in 1996. It may not have come out till 1998, but it's been around a long time. It's seen just a couple revisions over the years. Short, simple answer is it is the statute that allows folks to trespass away folks that have a license to carry concealed. So it used to be a concealed handgun license. When we got open carry, they added a separate section, 30-7, for open carry folks. But 30-6 has remained in effect for concealed handgun licenses, and then for folks with license to carry, carrying concealed. The constitutional carry of 2021 amended it. They amended sections C2 and E. But I wanted to go ahead and cover the whole statute. I did a video several years ago talking about a lot of the problems of it, and to my knowledge, last time I checked, there were still no court cases covering this, so these questions still apply, in my opinion. So be curious what y'all think. So what's unchanged is A and B. A says a license holder commits an offense if the license holder, 1, carries a concealed handgun under the authority of the license to carry laws on property of another without effective consent, and number 2, received notice that entry on the property by a license holder with a concealed handgun was forbidden. Okay, so bottom line, if you enter a property with notice, then you're breaking this statute. For purposes of this section, a person receives notice if the owner of the property or someone with apparent authority to act for the owner provides notice to the person by oral or written communication. So if somebody appears to be the owner or under some sort of authority, and they tell you subsection 3, entry has the meaning assigned by section 30.05b. C2 was changed. It's really not a substantive change. Just license holder has the meaning assigned by section 4603. Used to be 46035F, so they just moved it basically. But license holder is just somebody with a license to carry handgun in Texas. Written communication. This is where the argument starts. It is a card or other document on which is written language identical to the following. Notice it's identical. It is not or substantively similar. It's identical. Identical has a very specific legal meaning. It means exactly what you think. Identical. No change whatsoever. And this is one of my issues with this statute, is it's written to say, pursuant to section 30.06 Penal Code, parentheses, trespass by a license holder with a concealed handgun, end parentheses, a person licensed under subchapter H, chapter 411, government code, parentheses, handgun licensing law, end parentheses, may not enter this property with a concealed handgun. Those are in quotes. It says identical, and guess what? Those are mixed caps. I see signs all the time that are all caps. That's not identical. All caps is not identical to this. And there are plenty of statutes that have all caps. That's not all caps. Now, do you want to hang your hat on walking past the sign, reading the sign, being on camera reading the sign, whatever? Probably not. But if you get so-called caught and they don't have the identical language, that would be the first argument I'd have, is it's not identical. Or B, a sign on the property that includes the language described by paragraph A in both English and Spanish. So the language I just read to you in English and Spanish, how it would be identical since they don't have the Spanish translation there, I don't know, because I do know that Spanish translations are not always the same depending on who you ask to translate, particularly if they're Spain Spanish or Mexico Spanish or another version of Spanish. There may be differences in dialects and so forth. appears in contrasting colors with block letters at least 1 inch in height. This is another one that we've talked about in these other videos and talked about in the prior videos on this topic. Contrasting colors, in my opinion, does not mean clear glass with vinyl letters on it. Clear is not a color. Glass is not a color. It needs to be a sign. It needs to be preferably a white sign with black letters or a black sign with white letters. That's going to be your best arguments for contrasting colors. Anything else, to me, you're not really complying with the statute, at least the letter of the statute. And that's all we have. We don't have court cases saying otherwise. And arguably any court case that says that this doesn't mean what it says is really not going to be lawful. They'd really be bending the rules to try to come up with a decision there. That would be more of a political, legislating from the bench type of decision rather than actually statutory interpretation and following the law like they're supposed to. And 3 is displayed in a conspicuous manner clearly visible to the public. None of that's defined. I mean, we've all been places where there's a little sign somewhere by the front door. Maybe it's facing inward so you wouldn't see it walking in the place. Maybe it's there with 20 other signs and so it just kind of blends in. I mean, you know, you walk into a grocery store nowadays, it seems like there's 20 different signs up talking about everything from alcohol and smoking and handguns and COVID and masks and you name it. And so, you know, a lot of times I think these signs can get lost. The offense is a Class C misdemeanor punishable by a fine not to exceed $200, except that the offense is a Class A if it's shown on the trial of the offense that after entering the property, the license holder was personally given the notice by oral communication described by subsection B and subsequently failed to depart. All right, we know what they were trying to say there. They're trying to say you violate, it's just a ticket, Class C misdemeanor, $200 fine. If they tell you to leave and you don't leave, it jumps up to a Class A. Here's where they didn't help themselves. Subsequently failed to depart. What does subsequently mean? It's not, doesn't say immediately leave. It doesn't say leave within 30 seconds or a minute or whatever. Subsequently, when it's defined in the dictionary, just means later. So if we look in here, subsequent means following in time, coming or being later than something else, succeeding. So following in time. So if you walk into a place and they say, hey, we don't allow concealed carry, you need to leave, and you go, okay, I'm going to finish my grocery shopping and then I'll leave, arguably you've subsequently left. Now, I'm not recommending that you do that by any means, okay? I'm just pointing out where there's areas to argue these. I have judge friends and, you know, they act like this is so clear or whatever, but honestly, if you got in front of an actual appellate court and argued these things, these are not clear. The problem you run across is most judges are anti-gun, at least when it comes to you carrying, so they're going to always side against you, it seems. Then E was amended, and now it reads, it is an exception to the application of this section that the property on which the license holder carries a handgun is owned or leased by a government entity and is not a premises or other place on which the license holder is prohibited from carrying a handgun under section 4603. So they just deleted the 46035 part there. Huge problem with this. What's the difference between walking into a publicly owned place with a sign up versus walking into a courtroom with the sign up? I'll give you a hint. It's a felony to walk into the courtroom. It's a Class C misdemeanor to walk into the public place. So now I realize, okay, again, I understand all this stuff way more than you probably realize. I'm just throwing these out there to spark your thoughts, okay? But what I'm saying is, let's say you don't know it's a courtroom and they have a 30-6 sign up. You're taught in your classes that that sign is a Class C misdemeanor $200 fine. Now again, not everybody's going to want to violate that, but there are people that would say, you know what, I don't care. I'd rather be carrying, and if I get a ticket, I get a ticket. I'll pay a $200 fine to know that I'm safe and my family's safe. So there are lots of people out there that ignore these signs, okay? So if you ignore the sign and you go into a felony area thinking that you've committed a Class C misdemeanor, most people are not willing to commit a felony. A lot of people are willing to commit a Class C misdemeanor. I mean, how many people every day speed and don't think anything of it? They get a ticket, they pay it, they do defensive driving, whatever, and they go on with their lives. But if speeding was a felony, I guarantee you most people would be very reluctant to speed. Same thing here. So that's my point. Instead of having a sign that implies that it's a Class C misdemeanor, there needs to be a different sign for 4603 violations than there is for 30-06. That's my whole point there. And by leaving that up to where they can put a 30-06 sign, to me, is a problem that shouldn't be there. They left in place E1, which is it's a defense to prosecution under the section that the license holder is an owner of an apartment in a condominium regime governed by Chapter 81 of the Property Code, an owner of a condominium unit governed by Chapter 82 of the Property Code, a tenant or guest of an owner described by paragraph A or B, or a guest of a tenant of an owner described by paragraph A or B, and 2, the license holder carries or stores a handgun in the condominium, apartment, or unit owner's apartment or unit, carries a handgun directly en route to or from the condominium apartment or unit owner's apartment or unit, carries a handgun directly en route to or from the license holder's vehicle located in a parking area provided for the residents or guests of the condominium property, or D, carries or stores a handgun in the license holder's vehicle located in a parking area provided for residents or guests of the condominium property. All right, I don't like the way they said condominium apartment. You know, if you remember a while back, there was the Chiarini case, and I'll just give you the basic facts there. This was before open carry. A guy was open carrying a gun in a condominium unit. He was arrested for violating 4602, because back then, remember, there wasn't the open carry provision, so it was just carrying a weapon unlawfully. He was convicted and overturned on appeal. Both appellate courts got it right, in my opinion, very sound logic. It was both a right to carry statute as well as a limit on carry statute, and what they came up with was he was a condominium owner, so he owned a unit within the condominiums, but he also owned an undivided interest in all of the common areas of the condominium complex. And so he was carrying basically in his premises because he was a common owner of these common areas, and therefore not in violation of 4602. I don't know whatever happened to him. I don't know, he may have spent time in jail waiting for this appeal to come through. His life may be totally screwed up, but he did give us a great case to help kind of support others that are charged with these sorts of things. This particular here, I mean, it's kind of conflicting because you have rights to carry to and from your place of residence, your vehicle and everything. So I don't know why they added this particular part here, and like I said, I don't like the language. So E1 is basically for your condominium owners. Again, I don't think it's necessary because of your rights to carry under 4602 to move in from your home and whatever. E2, it's a defense prosecution under section that the license holder is a tenant of a leased premises governed by Chapter 92 of the Property Code, or the tenant's guest, and the license holder again carries it in the rental unit, directly to or from the rental unit, directly to or from the car, and so on. So again, redundant. You already have a right to carry there. Defense prosecution, the tenant of a manufactured home lot, tenant's guest, again, same things there. Redundant, not needed. F, it's a defense prosecution under this section that the license holder is a volunteer emergency services personnel as defined by 4601. So basically they can't put up a 30-06 sign and prevent the emergency services folks, or in this case it says the volunteer ones. G, it's defense prosecution under section that the license holder was personally given notice by oral communication and promptly departed. So on one hand they say it's a $200 fine, and then they say, well, if you leave it's nothing. So, you know, like I always say, your best act is if you're told that they're not allowing a handgun, to just leave. You know, that's your safest option, not going to cause you trouble. Anything else, yes, there are holes in this statute. If you want to be the test case, if you want to go through the court system like Mr. Chiarini did and give us a great precedent-setting case to help everyone else, that's awesome. But, you know, most of us don't have the ability to go through that, the financial means, the time to spend in jail waiting, etc. So it's not a realistic thing for most of us to challenge this. I just throw out there all these different holes in the statute, so if you are unfortunately charged with something and there is a gray area or question, I've showed you where I think the biggest holes in the statute are. Anyway, not a lot of changes from the constitutional carry as far as the 30-06 sign. If you have a license to carry, you still got to watch for those signs. You still got to comply with them. If you pass one of those and you're told to leave, it's best to just go ahead and leave. Hope this video was helpful. If you have any questions, please leave them in the comments and I'll do my best to answer.